All right, well, good morning, everyone. This is CR 2015, and doggone it, I forgot. I thought I had counsel. Carrie, go ahead. All right, good morning, everyone. This is CR 2015-00862, the State of Arizona versus Stephen Jones. President of the courtroom is Mr. Barker, Deputy County Attorney for the state. Also, I have Mr. Diesel, who is present as counsel for, I think, some of the victims, if not all of them, for a civil case. We also do have other members as well. On the phone, I have Mr. McCowan and Mr. Davidson. Mr. McCowan, good morning. Can you hear me? And Mr. Davidson, can you hear me? All right. This is the time set for a case management conference. I note that there are a couple of matters, actually 3 matters, that I need to discuss with counsel and make sure we're clear, just kind of briefly. I don't think that Mr. Barker's time to respond to the defense motion to remand to the grand jury has run yet. I think he has to the end of this month, if I'm not correct. Is that, if I'm not mistaken?
I think that's right, Judge. We had asked for an extension on that deadline because I'm in trial. Also, Mr. Shea's in trial. I don't think there was any opposition.
I didn't note a date, though, a date due on that. So,
and I don't have that in my file either, Judge. I think we'd asked for an extension. I don't know if we ever got an actual date.
Your due date was the 7th, wasn't it?
I have the order here, Judge. It says we had filed for a motion to extend the deadline. You indicated February 10th would be our deadline for that motion, so we'll definitely have something filed by that time.
All right.
And Judge, maybe to make it easy, we could also, because I know the other motion outstanding is the motion to modify release. We could also have our response by that time as well.
Any objection, Mr. Davidson, Mr. Cowan? Okay. All righty. Well, that takes care of 2. I wanted to set that up. How long do you anticipate that conditions of release hearing would take? Anyone? I'll take anybody's idea.
Well, for the state, Judge, I don't think more than an hour. I'll defer to the defense on that, though.
Okay, Okay, that was Mr. Davidson. Oh, I'm sorry. Okay, the third and probably the most significant matter is the list that was provided, the witness list that was provided. The witness list lists my cousin, Mike Slayton, Detective Mike Slayton, on it as a witness. It's always been my practice that if Detective Slayton is on a case, obviously I recuse from that case. There's only one circumstance that I didn't take that action, and that was where both parties stipulated that he would not be called as a witness. He was simply listed. I think, Mr. Barker, that was the Hiko Wilson case. I think he took a couple of pictures or collected some evidence. The party stipulated he would not be called and that none of the actions that he took would be challenged on that. So Do you have an idea? Can you kind of give me an idea? Because we might be able to take care of this matter now.
I think we can, Judge. Mike Slayton was on the scene. He was collecting evidence, probably similar to what he did in Hiko Wilson. I have no problem not calling him. In fact, I discussed this with Detective Rucker yesterday to make sure that there was nothing else he did that was significant enough that we would need to call him. So I would be fine stipulating to not calling him. I don't think there's any need to challenge what he did. Again, he was collecting evidence at the scene along with other detectives that were there that morning.
All right. Well, Mr. Davidson, Mr. Cowan, here, let me kind of tell you where I'm at on this. If there's a stipulation, which obviously requires that you take a look at what Detective Slayton did and make a determination as to whether or not you will call him, then that will obviously impact whether or not you stipulate that he will not be called as a witness. I want what I'd like you to do is to talk with Mr. Barker and review the evidence, review the actions of Detective Slayton, and see whether or not you would agree to that stipulation, or the parties agree that he's not a witness, in essence, by the stipulation, and that nothing that he did would be challenged. Then I'll go ahead and remain on the case. If, however, there's the slightest possibility that he could be called as a witness, or that his collection of evidence could be challenged, and I'm going to recuse off the case. So, Mr. McCowan, Mr. Davidson, I'll give you an opportunity to take a close look at what Detective Slayton did and talk with Mr. Barker, Mr. Shea. If I could get a response within 15 days, I'd appreciate it, and then we can. Okay. All right. All righty. Mr. Davidson, Mr. Cowan, who's leading today? I need to ask that. Who's leading today? Okay. How about discovery and disclosure? Who's gonna take the one on that? Okay, and this is Mr. McCowan? Okay. All right. Go ahead, Mr. Davidson. Have you filed your? Okay. Mr. Barker, did you filed and have been updating your 15.1? I assume, as I recall.
That's correct, Your Honor. And I've also been in touch with the lab down in Phoenix. They're doing a lot of the test work in this case, so they know that we're trying to get this moving. So I've talked to them. Also, we listed in our witness list Tom Bevel. He's a reconstructionist. We'll be supplying a lot of the materials to him to review, and then we'll get a report from him, and I'll get a better timeline on that in the future. But otherwise, we're up to date on disclosure.
Mr. Davidson, has defense filed their 15-2? Okay, all right. What are we looking at? Any kind of time frame with the outstanding lab analysis? Do you have any kind of projected time frame?
It's a little complicated, Judge. When I spoke to them, most of these are going to Phoenix now. Apparently there's a backlog in this northern Arizona crime lab, so most of these are going to Phoenix, and they're taking them in piecemeal. So they're only allowing us to test 5 items at a time, which is going to be problematic in this case since we have so much that we wanted submitted. They indicated, within a couple months they'll get those items, those first items done. I told them that I would like to know before then if we could submit more items to have them tested and get them in a fast track, because I told them this case is likely to go to trial. We're going to need those items soon so that we can discuss trial dates. So that's where we're at, Judge. I'm doing my best to communicate with the lab. Obviously, they have other cases that are important as well, but I think within 2 months we'll have a better idea.
Let me ask for some clarification. Is the Northern Arizona Regional Crime Lab doing any testing of any of the items?
No.
They've all been sent to Phoenix.
All to Phoenix.
Phoenix takes 5 at a time.
Well, that's their policy right now, to take 5, just the 5 most important, what they deem most important are items.
Okay,
they're going to test
they
those.
deem most important, or what you deem?
Well,
most
what we
important?
discuss is most important.
Okay.
Correct. So we have a discussion with them to get those first 5 items done. There are a lot more than that
And
we're asking to be done.
Those first 5 items will be done in approximately 2 months.
That's what they indicated, yes.
And how many items have been sent down there, approximately?
Around 30.
Okay.
As you can imagine, Judge, this scene is complicated. There's a lot of blood at the scene. A lot of different victims were bleeding at the time. So there's quite a bit of analysis to be done. They have indicated they're being cooperative. They've indicated that they'll talk to me and we'll get this going as quickly as we can. But this, as you know, is always an issue. So as soon as we get a trial date, I think that will help their timeline as well.
Okay. Oh, are we looking in 2018?
No, Judge. I'm ready to try this at the end of the year, but I know the defense would like some additional time.
Well, I understand that. I don't say that tongue-in-cheek because of the fact that it's taking 2 months to do 5 items. You've got 30 items. That's
right.
12 to 14 months from now.
Right. I understand, Judge, and I understand the frustration. If we get a trial date, I know that puts everything on a fast track because they know there's a deadline. They know that they have to get some stuff done.
How about if I set trial for March 1st?
Fine with me.
Would that get them going?
It's fine with me, Judge. Maybe set it tomorrow.
We could set a non-firm trial date. We just don't have to let them know it's non-firm.
That's
right?
That's one option.
Okay. Well, we might have to get creative. All right. Is there any issues from defense perspective that I need to address or we need to put on the record? Yeah, here's what I intend on doing, Mr. Davidson. As soon as you and Mr. McCowan review the issue regarding Detective Slayton and make a determination, if it appears that I will remain on the case, then what I'll do is I'll just probably get counsel on the phone for about a 5-minute. Let's get our calendars out and look at what we need to do for the motion to remand and the conditions of release hearing, and just set the dates for those. Okay. Mr. Barker, are you okay with that?
That would work, yeah, thank you.
Any issues from the state's perspective that need to be brought before the court we need to address?
Not at this time, thank you.
Okay. All right. And I also want to say for the record that Mr. Jones' presence was waived for this proceeding. Mr. McCowan, Mr. Davidson, I'm a little hesitant to do this because it's kind of an open-ended date, depending on how the issue with Detective Slayton works out. But are you willing to waive time to the next proceeding? And that would be the next earliest proceeding. And I don't know what that would be. It might be the conditions release hearing. It might be the hearing on the motion to remand. Yeah, I know, and I would imagine that we could, if the conditions of release hearing is going to take no more than basically half a day, I would imagine that we could probably get that in towards the end of February. I started trial, a malpractice case in what's the 18th, 17th, and that's scheduled to go for about 8 days. So that brings us up to about the 25th or so, and then maybe towards the end of February. So the problem is we're at the 21st, and I don't want to try and rush you in terms of trying to get something set for the second week of February. If we can't get it towards the end of February, then we're looking probably around the first week of March. That's all right. Hold on one second. Carrie's here. I have another trial? What is it? And how long is that one?
8 days too.
So we finish up here with that malpractice case, with the Barone case on here, right? That's the end of it. Well, counsel, the only thing that I've got, it looks like, I'm doing back-to-back trials starting the 17th, and then I go through, is APS, is that going to go?
8 days.
Then I start another trial the first week of March. That goes till March 11th. That's right. I might have to just not do it.
So does that mean the end of February is still open, Judge?
The end of February is looking tight, because I start that one trial, that civil trial, on the 16th, 17th, and then I go to the end. I go right to February 26th, 27th, and 28th of the weekend. Then I pick right back up with another civil case for another 2 trial weeks, and that's supposed to end on March 11th. I don't know if counsel have children or whatever, but spring break at least could possibly roll into March 14th. There might be on that, so that doesn't impact me. It doesn't impact. It may not impact anyone, but is that Mr. McCowan? Okay, Mr. Davidson. Okay. Sure. That's probably that's got to be settled first before we even talk about it. So we start setting dates for hearings. Okay. I'll wait to hear from counsel regarding the conflict issue and possible recusal, and then as soon as I get the notification, then I'll get on the phone and talk to counsel. Does that work for defense? And for state?
It does. Thank you.
All right. Okay. All right, gentlemen, we'll go ahead and stand adjourned. All right. Yes, sir.